Today, I want to talk to you about patents. First, let's discuss the roles in the patent field. There's many different positions that one can have, and they include patent agent, a patent attorney, patent examiner, litigation attorney, and patent judges. So patent agents, they don't need to go to law school. They basically have to have an engineering background and that they've passed the patent bar exam. They can file, or what they call prosecution. They can prosecute a patent with the United States Patent Office, but they won't be able to do any litigation or any trial work. They're not an attorney. On the flip side, a patent attorney has also taken the patent bar and has taken the state bar. So he or she would be able to file suit to enforce your rights as a patent owner and also file patents. A patent examiner qualifies for the patent bar exam but does not need to take it. They're working for the patent office, and they're the ones who are going to review the patent application. A litigation attorney is just, argues patent related matters in court. They don't need to be patent bar licensed, but if they're not patent bar licensed, they cannot file patents within the patent office. And then there are patent judges that decide patent related matters that have been appealed within the patent office. There's a whole system for appealing rejections from patent examiners, etc. So there are. And then even appeals from the patent judges in the patent office can be later on appealed to federal courts and so on. So I just want to let you know about some types of patents. There's provisional and non-provisional. Basically, provisional is just a placeholder. It's not going to get reviewed by any patent examiner until that provisional becomes a non-provisional patent. The non-provisional patents are the ones that get reviewed. And there are utility patents, design patents, and plant patents. So utility patent is granted to any new or improved and useful machine, product, process, or composition of matter. A design patent is given for any ornamental design of a functional item that is also new or novel. And then plant patents are given to novel, asexual reproduction of plants. So any discovery and reproduction of a new plant that's asexual may obtain a patent. But what is a patent? A patent is basically just a property right. It's granted to an inventor, and it conveys exclusive rights to the invention. The owner of the patent doesn't have to produce it, but they can exclude anybody from making, using, selling, offering for sale, or importing your invention. Well, who can get a patent? It's whoever invents or discovers any new or useful process, machine, manufacture, or composition of matter. And the term of a patent is 20 years from the date of filing. Design patents are typically 15 years from the date of filing. And in 2012, the most recent major patent act that was passed, the United States had moved from a first to invent country. Now we are a first to file country. So there's a big difference. The rest of the world has been mainly first to file, and the United States finally came around to joining kind of the rest of the world. So delete that little second. Patent searching. There's two types of patent search. There's the patentability or novelty search, and then there's the freedom to operate search. There's pros of searching and cons of searching. Obviously, pros are if you do find a patent that is exactly like your invention, that means your patent is not novel, it's not new, and you won't have to waste time down the line to file patents. And just kind of some cons of searching is that there's always going to be some uncertainty when you do a search, because when you file a patent, the patent isn't published until roughly 18 months later. That could be a year and a half or even up to 2 years later than the filing. And a patent search is not going to discover or reveal any of those applications that haven't been published. So you are going to be uncertain for about 18 months of a search. But you always want to do a search prior to filing a patent. It's almost impossible for anybody to tell you that your invention is new or not without conducting a full comprehensive patentability search. Now I want to talk to you about the parts of a patent. A patent is broken up into the drawings, the specifications, and the claims. It's kind of like a lab report in a legal sense. The drawings and the specifications are going to help explain the claims. And the claims are the most important part of the patent section. They define your exclusive invention and allow you to kind of create a fence around your invention, and that will be able to exclude others from making, using, selling, or offering for sale. The patent has to be specific enough to enable others in that similar field that they can also create or use the invention that you have filed. So if it does not enable others, then it won't be considered clear enough, and there'll be a specification rejection later on. I get more into it. So common office action rejections from patent examiners can include novelty, obviousness, and unclear and indefinite. So novelty basically is the invention new? And if it's not, the patent examiner is going to issue a office action rejection for novelty. Patent examiner can also issue a rejection for obviousness. It could be the invention is new, but the invention contains or combines other references together, which would be considered obvious. It's a very subjective analysis, and it's very tough to overcome. A proper patent search is going to help you overcome the novelty rejections and the obviousness rejections. So that's the importance of a patent search. And then the third type of rejection from the patent examiner is for unclear and indefinite. And I mentioned that if the specification doesn't enable others to use that invention or make that invention, it won't be allowed, and the patent examiner will reject it.